Welcome, everyone, to this edition of the Transatlantic Currents by the Center on U.S. Politics and Power at the Finnish Institute of International Affairs. I'm Charlie Pasternak. I'm the lead researcher leading U.S. research at the Institute. Today's topic is an incredibly pertinent, interesting, and important one. And as is wont at the Transatlantic Currents, we have an exceptional expert from the US to talk about this. I will be very brief and just say administratively, remember to write your questions into the chat. I will take them from there in the latter part of our hour. And I'd like to start by giving a brief introduction to our non-resident fellow at FIA, Ambassador Deborah McCarthy. She was ambassador in Lithuania. She was also a deputy in Greece, in Nicaragua. She has a master's degree from Georgetown and is one of the two resident fellows, along with Leo Michel, who runs the Transatlantic Currents. With those words, Deborah, take it away.
Thank you, Charlie, and good afternoon, everyone. And thank you for joining us for what I think is going to be a very interesting discussion with our special guest, Elizabeth Goitein, who is the Senior Director for the Liberty and National Security Program at the Brennan Center for Justice at NYU's School of Law. She's a nationally recognized expert on presidential emergency powers. So we will jump right in because I have lots of questions, and I know her answers are going to be very revealing to all of us. Well, this Trump administration has begun its mandate with a dizzying amount of actions, including 7 national emergencies, which include 1 at the southern border, 1 on energy, 2 imposing sanctions on various organizations, and 3 that have allowed him to impose tariffs on our partners, Canada and Mexico, but as well on China. The US Constitution gives the president no specific emergency powers, but the US president does have vast authorities under an emergency declaration, authorities that have been given by Congress over time. So Liza, I'd like to start, if you can explain how emergency declarations work and give us a sense of the extent of the authorities that are made available by such declarations.
Absolutely. First, I want to thank you, Ambassador McCarthy, and the Finnish Institute of International Affairs for inviting me to speak to you. I'm really honored to be addressing such a distinguished audience. As Ambassador McCarthy said, the US Constitution is unusual in that it gives the president no express emergency powers. In the absence of a direct constitutional grant of authority, presidents have, for the most part, relied on Congress to provide them with the powers that they need to address emergencies. Congress has passed many such laws, but the most far-reaching of them is the National Emergencies Act of 1976. Under this law, the president has almost complete discretion to declare a national emergency. There's no definition of national emergency, and there are no substantive criteria that have to be met. Once he issues that declaration, it unlocks enhanced powers that are contained in about 150 different laws that Congress has passed over the decades and that are scattered across the US Code, all of which say something like, in a national emergency, the president can do X. Now, many of these laws seem quite measured and reasonable on their face. For instance, there's a law that allows the Secretary of Transportation to waive the weight limits on highways for the purpose of allowing jet fuel to be transported to Air Force bases. So you can see how that might come in useful during war. However, there are a few powers that truly seem like the stuff of autocratic regimes. One of the scariest, in my view, is a provision of the Communications Act dating back to 1942 that allows the president to take over or shut down radio communications facilities in a national emergency. If the president goes further and declares a threat of war, the president can then take over or shut down wire communications facilities. This provision was last invoked during World War II when wire communications meant telephone calls and telegrams, and most American households didn't even have a telephone. Today, it could arguably be used to assert control over US-based internet traffic. Some of the other powers that are available in a national emergency that are, to me, particularly worrisome include the power to freeze Americans' assets without due process or judicial approval, the power to exercise broad and unspecified powers over domestic transportation, and the power to detail members of the US Armed Forces to any nation. It's not hard to see how powers like these could be used in ways that violate civil liberties and, frankly, undermine democracy. And every year, Congress is adding new powers to the list. When the Brennan Center first compiled our guide to emergency powers in 2018, there were 136 of these powers. Just 7 years later, there are 150. I can't hear you, Ambassador McCarthy. I don't know if others can.
You're on mute.
Sorry, I put myself on mute so I could cough discreetly. Let me ask you, there's, as you know, tremendous potential for abuse on some of these authorities. Can you talk a little bit about how they've been used or abused in the past?
Yeah, it's a great question. Given how potent some of these authorities are, the most remarkable thing about this system of statutory emergency powers is probably how little abuse there has actually been until recently. Presidents have shown remarkable restraint in using these powers. At the Brennan Center, we found that 70% of these 150 provisions had never even been used. The glaring exception to that is the International Emergency Economic Powers Act, which has been routinely misused, and I think we might be getting to that later. Now, to be clear, if you go back and look at US history, you will find a handful of instances in which there have been truly egregious abuses of power during emergencies. And I'm talking about things that touch on basic human rights and fundamental freedoms. The internment of Japanese Americans during World War II, the torture of detainees after 9/11, warrantless wiretapping of Americans' international phone calls also after 9/11. But these abuses, for the most part, have not relied on the emergency powers that Congress provided. They have either been unauthorized by any statute, or in some cases, they've actually violated the laws passed by Congress. But there is a softer form of abuse that we have started to see in recent years that does rely on statutory emergency powers, and that's the exploitation of emergency powers in the absence of a true emergency to implement policy preferences that lack sufficient support in Congress. This started, I would argue, with President Trump's declaration of a national emergency at the southern border in 2019, which was an unprecedented abuse of authority for two reasons. First, even though the National Emergencies Act doesn't define what an emergency is, the word does have a meaning. And any dictionary that you choose to consult will include the same two common elements. The set of events or the circumstances have to be sudden and unforeseen, and it has to require immediate action and response. Now, this is not just a semantic detail. It is core to the purpose of emergency powers in the United States constitutional system. Emergency powers delegate extraordinary flexibility to the president based on the premise that Congress couldn't have foreseen the crisis at hand and lacks the ability to move quickly or flexibly enough after the fact. This rationale for short-circuiting the usual legislative framework and for shifting power from Congress to the president simply doesn't apply in the context of long-standing problems. So however serious a problem you may consider unlawful immigration to be, it was not a problem that arose suddenly in February of 2019. Indeed, at the time, unlawful border crossings were hovering near a 40-year low. Moreover, Trump himself made it clear that immediate action wasn't required He said, I didn't have to declare an emergency. I could have taken longer to build the wall. I just prefer to do it faster. That's a quote. And worse, Trump was using emergency powers for the express purpose of getting around Congress, something he openly acknowledged. Congress had repeatedly and consistently refused to provide funding for the border wall. And no previous president had ever declared a national emergency for that purpose. So this use of emergency powers opened a door. And unfortunately, President Biden walked through that door when he used emergency powers to forgive student loan debt. Like unlawful migration, student loan debt is a long-standing problem. And at the point that Biden announced his loan forgiveness program, there were several bills that were pending in Congress to address this problem, but Congress had chosen not to pass them. So this too looked more like a congressional workaround than an actual emergency response. Fast forward to the present, and Trump is now relying heavily on emergency declarations to implement policies like steep tariffs that he would not be able to get through Congress, or at least not through the Senate, which basically there's a 60 vote threshold in the Senate for most actions, and Senate Republicans hold 53 seats.
Well, if I get sticking to the issue of migration, illegal migration, and the new declaration of emergency along the southern border. In the declaration and various executive orders related thereto, particularly one called Guaranteeing the State's Protection Against Invasion, he calls unlawful migration an invasion. And you've written about the dangers of using the term invasion, because it could lay the basis of misusing certain laws. Can you explain how the term is used in U.S. law and what its misuse could trigger?
Yeah. Trump used the term invasion to describe unlawful migration in multiple executive orders, but there are three that I particularly want to highlight. In one of his day one executive orders, he teed up a possible future invocation of the Alien Enemies Act. The Alien Enemies Act is an antiquated wartime authority that gives the president broad detention and deportation powers during a declared war or a proclaimed invasion by a foreign government or nation. It was last used during World War II to implement the internment of 31,000 non-US citizens of Japanese, German, and Italian descent without due process and based primarily on their ancestry. Trump also used the term in an order directing NORTHCOM, which is the military command for the North American continent, to draw up plans for a military campaign at the southern border. In this order, he appeared to be relying on a longstanding and widely accepted interpretation of the Constitution, under which presidents have inherent authority as commander-in-chief and can act on a temporary basis without congressional authorization to repel invasions of the United States. And finally, Trump used the term in an order entitled, the one you mentioned, Guaranteeing the State's Protection Against Invasion. This order refers to a clause in Article 4 of the Constitution that requires the United States, meaning Congress as well as the president, to protect states against invasion. And the executive order relies on this clause as a justification for several measures, including suspending asylum and other legal protections that Congress has established for migrants. In all three cases, Trump is misusing the term invasion. It is abundantly clear from the debates over the enactment of these provisions, from historical practice, in some cases from court decisions, that the term invasion in all three contexts refers to armed attacks by hostile foreign nations or other political entities, and not people crossing over the border because they're seeking to live and work in the United States. And even if a significant portion of undocumented migrants were criminals, which is a myth that really flies in the face of actual evidence, that would not transform their crossing the border into an act of war. And perhaps even more important, even if there were such an invasion taking place, it would not authorize the suspension of asylum law or other legal protections passed by Congress. The Supreme Court has made very clear that even if the president is acting pursuant to constitutional authority, even during wartime, the president must obey the laws that Congress has passed unless Congress was acting outside of its own authority in passing those laws. So in other words, if Congress has authority to pass immigration law, the president has to follow it. And there is no dispute that Congress has that authority. So this is a very dangerous theory of what an invasion means under the law that has absolutely no basis in precedent or law.
Well, speaking of Congress, there were supposed to be various restraints on presidential power in the 1976 Act that you mentioned in the beginning. And there have been efforts over the years to reassert Congress's authority over these emergency declarations. And I know the Brennan Center worked on one in 2023. Can you talk a little bit about Congress's role, what they've done and what they haven't done? And and are we likely to see any effort to affirm that authority?
Yeah. So the original National Emergencies Act included a very important protection against abuse. And that was the ability for Congress to terminate an emergency declaration issued by the president using a legislative veto. And that is a type of law that goes into effect without the president's signature. But in 1983, the Supreme Court held that legislative vetoes are unconstitutional. And so today, if Congress wants to terminate an emergency declaration, it effectively has to muster a veto-proof supermajority of both houses, which is nearly impossible in today's political environment. There are various efforts in Congress now to reform the National Emergencies Act by shoring up Congress's ability to act as a check against abuse. In other words, to restore the balance of power between the president and Congress that was thrown off by this Supreme Court decision. And the primary bill is called the Article 1 Act, and it requires declarations of national emergency to expire after 30 days unless Congress votes to approve the declaration using expedited procedures. Those procedures would not only allow Congress to move swiftly, but they would also allow any member to force a vote, and they would prohibit filibusters in the Senate. In other words, they would just get rid of some of the procedural tricks that are often used in Congress to thwart the will of the majority. An approved declaration could stay in place for up to a year, but if the president wanted to renew the declaration for a second year or a third or a fourth, each time he would have to go back to Congress and get approval again. This bill has remarkably broad and deep bipartisan support. It was first introduced in 2019 as a response to Trump declaring a national emergency at the southern border. The sponsor of the bill was Representative Mike Lee, a Republican, and there were 19 Republicans who co-sponsored the bill. The Democrats then picked up this reform and placed it in several Democratic reform bills. This legislation keeps being reintroduced in new Congresses. The last time it was reintroduced in 2023, it went through committees in both the House and in the Senate. In the House, the vote was unanimous voice vote. In the Senate, the vote was 13-1. And I cannot tell you how rare it is to see those kinds of numbers in Congress today. Unfortunately, Congress moves very slowly. And every time Congress gets close to passing this bill, something happens that saps the momentum. In 2021, it was President Biden taking office. I'm sad to say that for many on Capitol Hill and elsewhere, the urgency behind emergency powers reforms and other measures to shore up the guardrails of democracy really faded once they perceived that Trump was in the rearview mirror. At the end of last year, what kind of slowed the momentum, really stopped it, was Trump's election and a corresponding unwillingness by conservatives in Congress to do anything that might be seen as going against him. Whether conservatives will find their way back to the principles and values that they espoused before November of 2024 is the big question, not just for emergency powers reform, but for so many other things that need to happen if democracy is to survive in the United States.
That's quite sobering.
Yeah.
Let's turn to the role of the courts. So far, there have been, by my count, 112 challenges to Trump's administrative actions. We've had some restraining orders, some injunctions. One case made it to the Supreme Court, which actually was not in the administration's favor. As I note, these cases challenge administrative actions, but not the president's authority to declare a national emergency. And you've noted before that courts in general have been deferential to presidential determinations of emergencies. Do you expect there'll be challenges this time? And is any court action likely on the emergency powers?
Yeah, there will definitely be challenges. It is true that courts have generally been unwilling to probe the question of whether an emergency exists. Courts tend to see that as a political question. In other words, a question that has to be resolved by the political branches, the president and or Congress, rather than a legal question that can be resolved by the judicial branch. Having said that, there are some potential backstops in the political question doctrine. In some of its decisions, the Supreme Court suggested that there may be a bad faith exception to this doctrine in cases where the president has exceeded a permitted range of honest judgment, is the language from one of the cases. In another case where the court did find that the political question doctrine applied, the court acknowledged that the judiciary, quote, is not at liberty to shut its eyes to an obvious mistake, and that the courts will not stand impotent before an obvious instance of a manifestly unauthorized exercise of power. So in other words, it's possible for the president to go too far and to forfeit the deference that presidential actions in these areas would otherwise be owed. In addition, while courts are usually hesitant to weigh in on whether an emergency exists, they are much more willing to review whether the actions taken by the president are authorized under the specific emergency powers that the president invokes. And a good example would be Trump's 2019 declaration of a national emergency at the southern border. You know, as I mentioned before, there was no emergency by any dictionary definition of the term, but that is not the basis on which courts acted. Instead, they looked at whether the emergency power Trump invoked, which was a law that allows the Secretary of Defense to move money around within the department for military construction projects, actually authorized the construction of the border wall. And in multiple cases, courts held, either that this emergency power did not apply or that it was preempted by another law. So I think we might see something similar in this administration. I'll give you the example of the national emergencies that were declared for the purpose of imposing tariffs under the International Economic Emergency Powers Act, or IEEPA. Now, they have not gone into effect yet, the IEEPA tariffs. But if there was ever a case for the courts holding that an emergency doesn't exist and that the president has not exercised good faith in claiming an emergency, it's tariffs on Canada, right? I mean, the supposed emergency there is unlawful migration and fentanyl. Canada's role in unlawful migration and fentanyl is minimal. But the courts might still decide that they don't need to reach that question. And that's because IEEPA itself does not explicitly state that it authorizes tariffs. It has it delegates very broad powers to the president. There's a long list of actions the president can take, financial actions, imposing sanctions, restricting all kinds of transactions, but it doesn't explicitly use the word tariffs. And this Supreme Court in particular has been adamant that when the executive branch takes an action that has major political or economic significance, Congress has to have spoken clearly and explicitly and specifically to delegate that power to the executive branch. So I'm not saying that this is what the courts will hold, but I think there's at least a realistic prospect that they will reject the use of IEPA for tariffs. So we will see challenges, and I do think it's possible some of them could succeed.
Well, the National Emergencies Act of 1976 is not the only law that gives the president emergency powers. It's just one of the broadest. Other laws authorize enhanced powers and resources during specific types of emergencies. You've also discussed the existence of what you call pseudo-emergency powers, which don't require an emergency declaration, but still give the president extraordinary powers to address extraordinary circumstances. Can you talk a little bit about these other emergency powers and which ones give you the most concern and why?
Yeah, I would say the one I'm most concerned about is the Insurrection Act, which is one of those pseudo-emergency powers. It's the term Insurrection Act actually refers to a sort of amalgamation of laws that were passed between 1792 and 1874. So this is another antiquated law. It authorizes the president to deploy the U.S. armed forces domestically and use them to quell civil unrest or to enforce the law in a crisis. And in this way, it operates as an exception to the Posse Comitatus Act, which generally prohibits federal military personnel from participating in civilian law enforcement. The use of the military as a domestic police force represents a sharp departure from core constitutional values in the United States. The framers of the Constitution understood that an army turned inward can very quickly become an instrument of tyranny, and they were careful to subordinate the military to civilian authorities. But they also understood that there might be crisis situations in which military intervention was necessary. And so they left it to Congress to strike a careful balance between these competing considerations. Unfortunately, the Insurrection Act fails miserably in this task. The criteria for deployment under the Act are set forth in vague, archaic, and overbroad language, giving the president a tremendous amount of discretion to use troops for domestic law enforcement. For instance, one of the provisions of the law permits deployment to suppress any unlawful combination, which there's the archaic language, unlawful combination or conspiracy that opposes or obstructs the execution of the laws of the United States. So, taken literally, that would allow the president to deploy the army in response to two people conspiring to intimidate a witness in a federal trial. Now, a more realistic concern with that language would be deploying the military to suppress peaceful but unpermitted protests against a controversial executive order, right? So this is an extraordinary delegation of power, and yet the Insurrection Act in its current form contains virtually no checks against abuse. Earlier versions of the law allowed or required advanced judicial sign-off and placed time limits on the use of troops to enforce the law absent congressional approval. But Congress subsequently stripped those provisions out of the law, leaving no role for Congress or the courts. And the Supreme Court has held that the president's decision whether to deploy troops is one of these generally unreviewable questions, although again, there's a potential bad faith exception to that rule. So Trump has mentioned the Insurrection Act. He mentioned it many times during his campaign, excuse me, and he's threatened to invoke it in a variety of inappropriate ways, including to suppress protests against his presidency, to send the military into cities like New York and Chicago, which he describes as crime dens, and last but not least, to use the military for immigration enforcement purposes. Now, given how broad this law is, you might wonder how I can conclude that these would be abuses of the law or inappropriate uses. And the answer is that even though on its face, the Insurrection Act gives the president incredibly broad authority, the Department of Justice has historically interpreted it much more narrowly in keeping with the Constitution and tradition. Now, I fully expect that Attorney General Andy will take a different position, but we can still rightly understand the threatened implications that Trump has mentioned as abuses of the power conferred by the act.
And to clarify, Congress removed itself from playing a role under this act, if I understood correctly?
Yes, yes. Congress did, and it removed the requirements of judicial approval. And that's partly because initial uses of the Insurrection Act in the late 1700s and early 1800s, the presidents complied so faithfully with the provisions of the Insurrection Act that Congress kind of relaxed and said, well, maybe we don't need all of these safeguards because it seems like the presidents are acting responsibly. Well, the safeguards themselves were probably a big part of the president's acting responsibly.
Well, as I mentioned at the beginning, the U.S. Constitution is unusual in giving the president no express emergency powers. You've also written that presidents often do claim to have emergency powers under the Constitution. Can you explain why that is and what types of powers presidents have claimed?
So it is true that the Constitution does not give the president any explicit emergency powers. That hasn't stopped modern presidents and also some legal scholars from claiming that Article 2 of the Constitution gives presidents vast implied emergency powers. Some believe that the president has these powers by virtue of being the commander-in-chief. Others believe that the executive power itself implies the authority to do whatever the president deems necessary to address emergencies. Some have even argued that Congress has no authority to limit these implied powers. Unfortunately, we don't have a lot of guidance from the Supreme Court on this question. The court hasn't addressed the exercise of emergency powers very often. And when it has tended to try to resolve the case before it on the narrowest grounds it can. There are a few general principles that can be derived from the case law. The president is bound by the Constitution in emergencies as during all other times. His actions are on stronger footing when expressly authorized by Congress, and he can act against Congress's will, as I mentioned earlier, only if Congress has no jurisdiction over the subject matter. And if the constitutional rights of Americans are implicated, then the courts necessarily have a role to play. These are the general principles, but within these broad parameters, the outer bounds of the president's constitutional authority when responding to emergencies remain poorly defined. And if the scope of constitutional emergency powers were to come before the court today, we don't know what the court would hold. And that's really unnerving because in the few cases in our country's history where there have been these egregious abuses of power that I mentioned earlier, the internment of Japanese Americans, torture of detainees, these actions relied primarily on claims of constitutional authority, not on statutory powers. So if history is any guide, that's where the greatest danger lies.
Well, thank you for all this outline of what is an extraordinary ability of our president. I think I'd like to open it for questions. I've got more questions, but it'd be great to hear from our participants what their questions are, issues of concern, and certainly there is a lot to discuss. So Charlie, let me turn it to you for this.
Thank you. That was an absolutely amazing lay of the land. I was looking at questions and discussion. There are none there yet, which in Finland is not unusual. So I have a few, and I thought I would go into the proverbial deep end immediately because there are things that have been discussed around, not just in Finland, but in Europe. And I realize that you may not be able to or want to answer, but all sorts of questions about how these emergency powers could be used by the president regarding Canada, Mexico, Greenland is one set. And then I'll ask a second one, which is to the traditionally the idea, I guess, this is relating to NATO Article 5, was that the US president, if needed, could say, I'm going to use these powers to defend an ally. is there some sort of a reverse case where President Trump could argue, in fact, even if we are bound and the Senate wants us to do this, I'm going to say that we're not, claiming an emergency in the United States, and therefore we can't do anything for anyone else. So I guess pushing it towards foreign policy.
Yeah. I think if the president wanted to not come to the aid of a NATO ally, there's not an emergency power that would allow him to. It was kind of two separate questions: whether he might just not come to the aid of an ally, and then separately whether he would try to withdraw from the treaty. But in either instance, there is not an emergency power that's available to the president to do that. And I think. There are definitely questions about if going to the aid of an ally meant actually engaging in military operations under the U.S. Constitution. That is something that Congress would have to approve, even if it's pursuant to the treaty. However, these there are other ways, obviously, in which a president could come to the aid of an ally, and if what Trump sought to do was to unilaterally withdraw from a treaty, I think the best reading of the Constitution is that that's not a power that the president has, and that that's something that really the Senate would need to approve in the same way that the Senate approves entering into the treaty in the first place. I do think that it might behoove Congress to clarify that point. Because it's certainly something we have to worry about, given the way that President Trump has talked about NATO and the U.S. involvement in NATO. But so I think there is a concern here. But the short answer is there isn't an emergency power available to the president that Congress has passed that would just allow the president to say, we're not part of NATO anymore. We're not coming to the aid of our NATO allies. Now, as we saw with the use of the term invasion. Trump is claiming broad constitutional authorities where those authorities do not apply, and he is trying to use those authorities to do things that they do not justify.
Yeah.
So that's something we could see.
All right. And any thoughts on the neighbor to the south and the north and use of emergency powers there?
Again, I think it's not so much emergency powers that I would worry about. There are not emergency powers that would allow the president. I'm sorry?
There's not an emergency power to invade a neighbor.
Correct. There are emergency powers that allow the president to, bolster military strength, to call up reservists and to implement stop loss and things like that, but not to invade a neighbor. The question here is how this invasion language might play into a theory that we are under attack. I guess by Mexico. I mean, I assume we wouldn't go that far with Canada, but who knows? And that that could justify military operations, supposedly in self-defense, to repel an invasion. This would clearly be illegal. There is absolutely no basis for saying that we are under the type of sudden attack that under the Constitution justifies the president acting militarily and acting without congressional authorization. Right? Congress is the body that declares war. It would not be lawful. There are no emergency powers that allow it. Is it something we should be worried about? I don't know. I think there are a lot of things we need to be worried about that we shouldn't have to be worried about.
Thank you. I'll take a question. It's adjacent to this from revoking. Thank you very much for an enlightening discussion. I would like to know if this is a hot topic in the U.S. now, and if it is, where, kind of just the Hill, academia, government, among the people?
That's such a good question. If the number of emails and calls that I get from reporters and people who want me to come speak and explain things, if that is any gauge, I think this is a topic of interest. But I do run in somewhat rarefied circles, I guess. I mean, I don't know that. I think it is a topic of tremendous interest among people who are closely following what this administration are doing, who are, involved in politics, who are concerned about what's happening with our democracy. I wish it were a concern for everyone, but there are also so many competing concerns right now. I mean, in some ways, Trump has relied less on emergency powers than I expected that he would, much less, actually.
Wow.
And I think part of the reason for that is that he seems to be quite willing to ignore the constraints of ordinary non-emergency laws and the need to rely on emergency powers, which are much broader and much more flexible. That need is not as acute if a president is willing to just ignore the boundaries of non-emergency laws. So maybe for that reason, we really haven't seen the kind of reliance on emergency powers I was expecting yet. And I think yet is the operative word, because I do think a lot of these powers, like the Insurrection Act, like the Alien Enemies Act, are very appealing to Trump, in part because of just sort of the optics of them.
And they've been kind of flashed by the administration that we're thinking about this, be aware, or there's one more question.
And Charlie,
Deborah,
if I can just, I was just going to jump in.
I was just going to ask you to jump in, yeah.
On the, I guess, the public, or at least those who follow issues related to the president's powers and what's happening in Congress, are looking to see whether the administration adheres to some of the decisions that the courts have made.
Yes.
Like, for example, the one that made it to the Supreme Court only to be tossed back down, but basically ordering payment to a certain group for past monies, foreign assistance monies under certain contracts.
Right.
And whether they're going to be ignored, slow rolled, et cetera, and what the next steps are. And you know, you're the lawyer on this, but I think that's where people are focusing also.
Yes, and they should be focused on that. I think that is incredibly important, because if the president can become the judge of his own actions, then, I mean, that just completely dismantles the separation of powers. And the separation of powers, and this is something that I think is a bit abstract, I think, to some people, but is probably becoming more concrete under this administration. The separation of powers is the best protection we have against presidents becoming kings. So that is what's at stake in whether or not the Trump administration is going to faithfully obey these court orders, versus either sort of making a grand declaration that they're not bound by the courts, which is, you know, something we sort of see hints of in tweets by various people associated with the administration, or, as you put it, just by slow rolling the courts and sort of saying that the administration is complying while not actually complying. And that's another affront to the separation of powers. It's just a little less vocal.
I have a bunch of questions here now. I'll just go in order. Can presidential orders overrule state level legislation? It's a little on the side, but relevant. Yeah.
They can. I mean, or presidential orders that have the force of law, and that includes executive orders and regulations, as well as laws passed by Congress. Our federal law is supreme under the U.S. Constitution, and it would override conflicting state laws unless the federal law exceeds the authority of the federal government, because the federal government is, and Congress in particular, and the president is supposed to faithfully execute the laws passed by Congress. Congress is limited by the enumerated powers set forth in the Constitution. And the Constitution clearly states that the powers not enumerated are left to the states. And so there are certain state functions, like the police power, which is what it's called, which is how basically states sort of maintaining order within their own states. That is considered an exclusively state function. And for one thing that the federal government cannot do, for example, is to commandeer state officials to execute federal law. That is something that violates the Constitution. And that is relevant because some of Trump administration's memos and statements and plans involve targeting state and local officials who do not assist the federal government in conducting immigration enforcement. Now, it's framed as, these states are obstructing federal law, which is something the states cannot do. But in fact, what these states are doing is refusing to actually assist the federal government in implementing federal law. And that is something that the federal government cannot command the states to do.
And this is what we're seeing with even down to the city level refusing to cooperate with ICE or someone else.
Exactly. Exactly.
Okay. So again, thank you for enlightening presentation discussion from Sophia. Have you heard any reactions from European peers, academia or otherwise, to these violations, valid concerns you're describing? How do you see this impacting EU-US relations?
Wow.
Anything from?
I mean, so I've not directly heard from peers, but I have been witnessing the response of European leaders to Trump's abandonment of Ukraine and, seeming to ally himself with Russia. I would say, I mean, EU-US relations are facing a major challenge right now. I think that's the most diplomatic way to put it. Because as some of the language that Trump uses in describing our allies in Europe is, it seems, designed to create a rift between the US and the EU. So I find it incredibly sad as well as worrisome. And I hope it changes. I hope that, I don't know how to put it other than I hope that our allies in the EU understand that this, not that this is helpful in terms of what's happening with Ukraine and Russia, but this administration and its position on the EU and on Ukraine is not representative of what Americans feel and believe.
If I can jump in, if you look at the polls, exactly what Charlie was going to mention, if you look at the polls in general. But I wonder also if the fact that the president declared national emergency to slap on tariffs on Canada and Mexico, even though they're on, they're off, they're on, they're off, two of our closest neighbors, and again, using emergency powers to do what otherwise could be done administratively through various other mechanisms. That's also, rather a wake-up call.
Absolutely. And for us to say that, a country, let's just take Canada and the tariffs on Canada and that emergency declaration, which basically says that Canada's activities are a threat to the national security of the United States. And to me, when you take one of our closest, most longstanding allies, and you describe them as a national security threat to the United States, that statement does more harm to the security or foreign policy of the United States than anything that Canada has done. So I think it is very the effects of that, even if the tariffs are never imposed, the effects of that kind of language are very serious.
And in particular, when you think that Canada, after 9/11, under Article 5, came to our rescue and all our planes were able to land up there. I was up there at the time. It's quite egregious.
Yeah, there's a reason why these countries are why we consider them friends and allies, because that is how they've been, and that they have supported us when we needed their support.
Deborah, I don't know if you have a question. I had a question about a news item that I was in the US then when this happened a few weeks ago, but didn't really break the news horizon here. It has to do with using the military inside the US in some ways. 3 of the top JAGs were removed from Pentagon rather unceremoniously. Is there a way to interpret this in any other way than trying to lay the groundwork legally to then, I won't say give illegal orders, but using maybe the Insurrection Act or others in a way that they weren't meant to? Or how should one interpret this?
Yeah, well, it is a way to ensure loyalty to the president above all, rather than loyalty to the Constitution. It is a politicization of the military. And one of the things that I have learned in these last few years when I've been studying domestic deployment of the military, and I have been working closely with many retired generals, one of the things that I have learned is how fiercely the military guards its apolitical, nonpartisan nature. I mean, that is one of the tenets that is absolutely core to military service, at least among the sort of military leaders that I have been in contact with. It's part of why the American public has such trust in the US military. It's part of the very positive civil military relations that we have in this country. And dragging the military into politics, firing absolutely, top qualified military generals, replacing them with people who frankly have less qualifications, but who have loyalty to the president, potentially for the purposes of using the military domestically for something like mass deportation, which is politically incredibly controversial, and the military does not belong in that realm. The military is not supposed to be conducting immigration enforcement. That is a civilian function. And so you're not just pulling the military into an area where it is sort of ill-equipped to do the job, and that's constitutionally not the job it's supposed to be doing, but you are also dragging the military into politics in a way that is not going to be good for the military. And it is not going to be good for civil military relations going forward into the future.
Deborah?
I was just going to wrap up by asking a more broad, open question, which is the president has declared an estimated, well, I guess 7 national emergencies. And I think you alluded to this, but let me ask directly, how many of these respond to actual emergencies and how many are real abuses or misuses of emergency powers?
Yeah, I mean, I think all of them are inappropriate for different reasons. The first emergency declaration of his second term was basically a repeat of his 2019 declaration of an emergency at the southern border. It's a misuse of emergency powers now for the same reason it was then. It's addressing a longstanding issue. There's no sudden, unexpected crisis here. And in fact, unlawful border crossings were on a steady decrease at the point that he declared the emergency in January. So he also declared a national emergency to address a supposed energy crisis. The order directs the Secretary of Defense to conduct an assessment of the military's ability to acquire and transport energy, fuel that's needed to protect the homeland and to conduct operations abroad. And then it invokes a power that frees up funding for military construction projects and makes that power available to address, quote, any vulnerabilities identified in the assessment. So he's invoking emergency powers to address hypothetical problems that have not yet been identified, let alone, shown to be an emergency. And then finally, he invoked IEPA, International Emergency Economic Powers Act, for 3 purposes. The first purpose is tariffs, which we've talked about. On Mexico, Canada, and China. Mexico and Canada are on seemingly indefinite pause. And then he also used IEPA to impose sanctions on drug cartels and other transnational organizations that his administration designates as foreign terrorist organizations. That was simply unnecessary because there are already national emergency declarations in place issued by previous presidents that would authorize IEPA sanctions in those cases. So completely unnecessary. And then last but not least, he invoked IEPA to impose economic and financial sanctions on international criminal court employees who investigate, prosecute, or adjudicate war crimes allegedly conducted by US or allied personnel. And I think that one kind of speaks for itself. So yeah, I don't think any of them are valid.
Well, I know you're going to continue to explore and advise, and I think what you've done, Liza, in the US and now overseas is basically there's a whole civic education process that is required because many Americans, speaking inside the United States, are not aware of these powers. And not everyone cares outside of the Beltway, as we say sometimes in DC. But over time, should more emergencies, whether true or decided upon, be declared, and more assertions of power, I think more will be aware of this and concerned. And it goes to the very heart of our democracy. So thank you for shining the light for a while now on this issue. And I'm very glad to hear that you're also working a lot with our military, who I agree with you, and Charlie, I know, would very much agree, are so proud of the independence of our military and will attempt everything to maintain that as a sacred, I mean, it's a sacred trust.
Yes. Yes. It's been an incredible experience actually working with them.
I gather. Well, thank you. I gather those were the final content words. So I just wanted to thank you, Deborah and Liza, an absolutely amazing hour that has passed by. I'm sure we could have gone much longer. I still have some questions. Hopefully I can email them or something. Thank you.
Anyone can email me if they have questions. I'm happy.
Sure.
I can talk endlessly about this subject, and I'm very happy to talk with anyone.
Thank you. Thank you again for spending this time. Thank you to our audience, to questions. I'm sorry we didn't get quite to the very last one. But with those words, say webinar is closed. Thank you for attending. And because I forgot to say it, Liza and Deborah, could you hang on for a few minutes once everyone is left? No, thank you.
Sure.
Thank you.
Thank you.